All right, good morning, all you brave souls who are here timely. Thank you so very much. Welcome to the Sunday morning PASG conference here in lovely Fort Collins, and thank you to all those attendees that are watching remotely. This morning, we begin with a presentation by Brian Ludmer, Demosthenes, Lorandos, and Alissa Sherry. Did I pronounce your name correctly?
Alissa, but that's okay. I don't care.
Very good.
Go slow.
On surviving cross-examination.
This presentation is on surviving cross-examination, and I'm going to give a brief bio before we start. Demosthenes Lorandos studied science at the New School for Social Research. A psychologist for 50 years, he trained in law with the Jesuits at the University of Detroit. He has been a litigator for 30 years and is a member of the Bar of New York, California, Michigan, Tennessee, Washington, D.C., the 2nd, 6th, 9th, and 11th Federal Courts of Appeal, as well as the Bar of the United States of the Supreme Court. Brian Ludmer is a skilled attorney in business and family law. His practice focuses on high conflict divorce, parental alienation, and high net worth property and income disputes. Alissa Sherry, PhD, is a forensic psychologist with over 15 years of consulting experience, including 450 cases as either an expert witness, trial consultant, or forensic evaluator. Let's welcome our speakers.
Thank you. I just want to set the stage here. Never let it be said that Professor Harman does not have a wicked sense of humor. I'll tell you why. She said, okay, let's have a session on surviving cross-examination. Let me get the guy that wrote the book on how to cross-examine experts in the behavioral sciences, and that's me. Terrence Campbell and I wrote a book for West, 2 volumes, cross-examining experts in the behavioral sciences, how to get experts, how to do it, how to get right in there and do it. So let's get that guy, let's make him come all the way across the United States, let's bring him up to altitude, and then let's put him on the stage with an eminent forensic psychologist, Professor Sherry, and probably the nicest attorney on the planet and smartest attorney on the planet, who's really nice because he's from Canada, Brian Ludmer. And then let's turn him around backwards. And instead of having him talk about how to just grind them into the ground and just let's have him explain how to survive cross-examination. I mean, come on. So we're going to do something a little bit different today. Professor Sherry and Barrister Ludmer have many helpful hints and many do's and don'ts and many ideas that will help you and help you tell your experts how to survive cross-examination. And we're going to there's really 4 participants. There's Professor Sherry, Barrister Ludmer, me, and you guys. So what we're going to do is we're going to see where this goes. We're going to answer your questions. We're going to role play. We're going to interact. We're going to respond to some of the scenarios that Professor Sherry and Barrister Ludmer have created, and we're just going to see where it goes. So take it away, guys. Wait a minute. Wait.
Wait. What did you want? All right, got it.
Thanks. Okay, so first, right. You should have available, because we sent it in yesterday, a list of reference materials if you truly want to be an expert witness. And it's 4 or 5 pages long. It has all of the leading publications by scientists in this area who educate experts on how to testify, how to survive cross-examination, all the tools, all the case law, all the professional standards. So I assume that's going to be uploaded to the conference website. And the last 2 or 3 are Dr. Lorandos must-read publications. But there's an awful lot there from people who have been considered the leading scientists and clinician in the area of expert testimony over the last 30 years. So I would recommend that you take the time to go through that list. And yes, I have every single publication on that list. So what we want to do here today is demonstrate how to testify safely, because we need all of you to be successful experts, not only in the one case you're on, but in cases to follow. And yes, how you do in any particular case will be raised either for you or against you in subsequent cases. There is some case law on that as to whether that's fair or appropriate or what can be raised from previous cases, but you got to be on your best in every single case. You have to be on your best in other forums. So advocacy, everybody here is interested in this area, but if you're going to be an expert witness in PA cases, there's a limit to what you can and should do in advocacy contexts and in public speaking. So you have to practice defensively given some of the difficulties that we know are happening out there with respect to experts. So we encourage professional dialogue and expanding the science and knowledge, but you guys should not be involved in advocacy, lobbying, and that sort of thing. Most of you will know or know where to find the rules for the admission of expert evidence. That's the job of the lawyers. But if you practice defensively and avoid biases and avoid the types of things that make it difficult for us to get you qualified as experts, it will go more smoothly as well. So that's just, we're not going to try and turn you into lawyers here. That's just part of the relevant background. So we wanted to make this interactive, as Dr. Lorandos said, and Alyssa's going to introduce our case study, I guess, so that we can...
Oh, I'm going to talk about a few things about
Okay,
testimony.
perfect. So I just want to leave you with 3 thoughts, the 3 key things to remember in the course of testimony. One is prevention, 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 and that's avoiding biases in how you conduct your work, in maintaining a proper file, in following professional standards, in interviewing, not beyond reason, but interviewing the broad base of people that the participants in the family want you to interview, reading everything you've been given, maintaining an open clinical mind right through the whole process. You don't synthesize until the end. Everything else is a clinical hypothesis right through to the end to avoid confirmatory bias. So prevention. And then when you're testifying, stay within your lane. You're only one piece of the evidence that the case is going to hear, and you don't have to win the case. That'll spill over into advocacy. Your attitude is as if you were just an intervener, a friend of the court, what we call amicus curiae. If you maintain that attitude and you're helpful and you acknowledge the limitations of your work and you explain why you came to certain conclusions, then everything you're doing is defensible and it should be a fine experience. The last point is preparation, preparation, preparation. You shouldn't be surprised by anything that happens once you're on the stand. If you're a therapist, you've worked with the family 3 months, 6 months, 9 months, a year, 2 years, you know what the issues and the narratives are. You know why you ultimately came to the conclusion that you did. The same thing if you're a forensic evaluator. Everybody has tried real hard during the process to make you see things their way. You come to trial prepared that's where they're going. You're there as a friend of the court explaining why, in all the swirling, conflicting narratives, you came down to your conclusion one way or another as to what the primary causal factor of the dysfunction in the family is, why it won't heal, why are we in court today. So preparation, setting the groundwork properly as well, and then when you're testifying, calmly, the witness has all the power. You were there, you know, the lawyer cross-examining you was not there. So you have the high ground. If you stay within your lane, you don't argue, you explain, you're going to be fine. Thanks.
Hold the applause till the end. It's going to get better. Just wait.
Talk on this, does this work? Yeah, there you go. So, how many people in this room have testified as a therapist in one of these cases? Okay. How many people have testified as a somebody that's done an evaluation or ad litem or something like that? And how many of you are lawyers? Okay. How many of you are here because you want to testify and you're hoping to get some of that work, but you're not sure how to go about it? Anybody? Okay. Good. Well, hopefully there's going to be something for everybody here. So I'm, I guess, the forensic psychologist of the group, although Demos is just as good of a psychologist as I am. I'm not eminent, last I checked, whatever. But I am board certified forensic psychologist. And so I want to share with you a few things that I've learned over the years. Some of these things the hard way, some of these things the easy way. You know, first when you start out, there is a little bit of fake it till you make it. I remember when I was getting my first cases, and I would be on the phone with a lawyer, and he'd be using all this family law jargon. Oh, so-and-so, they've got joint managing conservator, and they're getting a modification, and I'm legit looking up what does joint managing conservator mean on the internet while I'm talking to him on the phone, because I have no idea what this language is that he's talking about. You know, now I know how to use all these words competently, but when you first start, you're going to feel like, I don't know what any of this means. It's okay to ask. It's definitely okay to look it up. So don't let that hold you back. I think one of the first things I would encourage people to do is dress nice. Dress not formally like, you know, a tuxedo, but, you know, the way you dress is one of the ways that you respect the court. And I have lots of really comfortable clothes that I wear when I'm working in my office, and then I have lots of uncomfortable clothes that I wear to court. I did just recently get rid of all my high heels, and I'm doing loafers now. That's been a big plus. And if you can find a way to dress nice and competently, but also still be comfortable, it will also help you project your best possible self, because you will feel some pride in the way that you look, in the way that you're putting yourself out there. And you don't want all that kind of insecurity stuff going on in the back of your head. This may be my issue. I don't know. Maybe some of you other women have the same issue, but that I really feel strongly about that. It's sort of like, I think of it as like putting my Wonder Woman costume on and going to court. The second thing I would say is that know your ethics code. I am licensed in Texas, Florida, and Michigan, and I also have that interjurisdictional license that has like reciprocity with like half the states. And it's interesting because Texas, even though they're so libertarian and don't want to have rules for anybody, they have 80 pages of board rules for behavior of psychologists. it is very detailed. I actually think it's an excellent set of board rules. Michigan doesn't have much of any of that. There's I think an unspoken maybe rule that they follow APA guidelines. I've read it several times. I haven't seen where they've made that explicit, but most of the only stuff that the board talks about in Michigan is, you know, how you obtain your license and how many hours you need of supervision and that kind of stuff. But they don't really address ethics. And then Florida has got a little bit of both. Like they do some of the important pieces, like don't sleep with your clients and some of that kind of stuff. But they don't. It's just somewhere in the middle. But all that being said, like you want to be very clear on there's, I think, 3 areas of ethics that you want to know like the back of your hand. One is going to be your licensing board and what they have to say. And it's good to just read that thing once a year. They make changes to that. And if you're not reading up on that once a year, you could really make some mistakes. The second is your professional organization ethics guidelines. So APA, some of you may be counselors, so the ACA also has a great ethics thing. I think a little bit better than APA's, honestly. And then the specialty guidelines for forensic psychology, I also think are super important. If you operate within those ethical guidelines, that's going to be part of your armor when dealing with cross-examination. Because if you're right, if your analysis of a family is correct, and you definitely have an alienator, let's say, in the family system, the man or woman that represents that alienator probably knows that as well. And so their only move, really, is to make you look like an idiot and cut you down at the knees. So if you have not followed your ethics code in some kind of way, that's going to be one of the first places they go. So really know your ethics code. If things come up, and they will with some of these families where you're like, I'm not sure what to do here, my code is a little vague about what to do here, call a colleague, talk it through, consult with somebody, because that's just such an important piece of your work. The second thing I would say is that, and the lawyers may tell me different. I'm interested in what the lawyers might have to say about this. As a psychologist, I'm in a Dalbert state. But I kind of would say whether you're in a Dalbert state or a Frye state, I would practice as if you were in a Dalbert state. Because the scientific approach to doing custody evaluations and psychological evaluations needs to be scientific. The things you do need to be peer reviewed. They need to be falsifiable. Somebody else needs to be able to replicate your findings. All these things that are a part of Dalbert, because that is the professional standard. So when Frye reads that your scientific technique is generally accepted as reliable in your relevant scientific community, your relevant scientific community uses Dalbert. And so you need to think about the work that you do from a Dalbert state of mind. Do you think that's fair to say?
Yeah, and Mohan in Canada, same difference.
Okay, I'm not as familiar with Canada, but okay, perfect. Just a couple more points about this. Read. be a voracious reader of your craft. You know, the custody evaluations, or if you're a therapist working with these certain types of families, read all of Demos's books. But no, seriously, read all of Jennifer Harman's work. It's so incredibly important. If you're just starting out and you want to do custody evaluations, read Jonathan Gould's book about scientifically crafted child custody evaluations. It's a quick, easy little book, and it really touches on the highlights of that. Yeah. Jonathan Gould is the author's name, and the book is Scientifically Crafted Child Custody Evaluations.
It's on the list that I've distributed.
Awesome, Brian, you're awesome. Another book is Melton's, Melton, Psychological Evaluations for the Courts. That's a little bit more of a broader forensic psychology book, but it's really good, because you will find in doing family law work that other things come up, like competency, or you know, just various issues, criminal law issues. That book will help you navigate the intersection of some of the other areas of law that you might come in contact with. And then I honestly think that Bill Burnett in Demos's latest book about parental alienation, science, and the law, like, that is going to be the Bible of what we do with regards to parental alienation and how we understand it in the courts. It's absolutely wonderful. So that would be another one that I would really recommend. When you make sure that you're reading as much current stuff as you can. If you're somebody that likes to cite literature in your custody evaluations, and I'm kind of that person, make sure you've read it, the things that you cite, because I promise you, you will run into a cross-examiner who will. And if you're kind of loosey-goosey about what you think that article says, or you're just copying somebody else's citations and you don't get that original citation and read it for yourself, that's going to end up being a problem. I think we've talked just a little bit about Joan Meyer's stuff. My analysis of Joan Meyer's work is that she says she writes a piece of misinformation, and then in the next thing she writes, she cites herself in the previous article of having, like, as if this statement that she made was absolutely true, and as if there'd been research done about it. And when you go back, it's just sort of like sand built on sand built on sand, and it's just, none of it is, there's no original source to really support what she's saying, but the way she writes about it makes it look like it, right? So you want to make sure that when you cite something, you've read it, you've got a copy of it. Sometimes lawyers will ask for a copy of every article you cite in a report that you write, so you want to make sure you have that available. I think, as just a side note, there's no such thing as over-preparing. You are going to know more about this case than either lawyer will know, mostly because lawyer for mom has only been hearing mom's story. Lawyer for dad has only really been hearing dad's story. You've been meeting with the children. You've talked to collaterals. You've looked at all these records. You're going to know the bigger picture. But that being said, you want to be over-prepared so that when the cross-examination comes from the side of the case that doesn't really like your opinions, you feel like you can answer it without it giving you a panic attack. And that's why over-preparing is good. Be loyal to truth and advocacy. Accuracy, sorry. 7:30. I'm so surprised all these people are here, and we're really grateful for that. Loyal to truth and accuracy. Not to your ego, not to your role, not to a particular side. You know, if you've been, maybe you've been hired by one side to kind of look at somebody else's work or whatever. Not to any kind of self-preservation, not to the side that hired you. You will make mistakes in your career. You'll forget to do something. You'll forget to look at something. Maybe you'll run out of time. But whatever it is, you'll get it wrong. And it's not your job to just totally dig your heels in and defend your position. It's not about you. It's about what's best for the child. And you just keep that in your mind. And if you can talk yourself out of thinking, this is not about me, then you'll be able to weather whatever criticisms come your way a lot better. Because again, it isn't about you as a human being. It's about getting it right and being able to come back to the table and say, you know what, you're right, I did write this down wrong, or I forgot this word and it totally changed the meaning of the sentence. Let me correct that and get that back to you. That doesn't mean you make every single correction that some side wants you to make, because that might not be truth and accuracy either. But you're open to looking at the concerns that one side or the other has. Now, sometimes the side that is not happy with you doesn't want to tell you what those concerns are until the day of litigation. I have a little statement, and when I write these reports, that basically says, I want to know if there are any errors in this report. I expect you, if there are, I expect you to let me know about it before we go to court. If you don't, I'm going to assume that you have not done that because you want to use it as a strategy for litigation instead of letting me correct my report so that it is in the best interest of the child. And then when they try to do that, then the other side just makes me read that section of my report, and then it just kind of undermines the attempts to kind of do that. And so I think your goal overall is to use all of these strategies to find your authentic self as an evaluator or a therapist, if that makes any sense. Like, you know, you're dressing what feels comfortable to you and projects your best possible self. You've read your ethics and you're so grounded in your ethics that somebody can ask you a question off the cuff about any part of your ethics and you'll be able to answer it. You'll have a good sense of what the academic literature says and the practice literature says about how you're supposed to understand parental alienation, or how you're supposed to conduct a forensic evaluation, or do forensic therapy. I would say for people doing therapy, be very careful. Do not make custody and access recommendations when you're a therapist. That's an ethics line that's very dangerous. You can say lots of things that walk right up to that line, but just don't cross the line. Be mindful of the words that you choose, and we're going to do practice cross-examinations, and we'll see if I'm able to do that under Demos's and Brian's, whatever. And if any of you, I brought some cards with me, obviously. If any of you want to talk to me after or want to consult with me when all this is done, or you're just starting and you want a little bit of support or whatever, I love it. I was a professor at the University of Texas for 15 years. I love to teach. I taught ethics. I taught psychological assessment. I'm happy to help anybody that needs it. But I think now you're going to watch me get beaten up.
Yeah, but before that, I want to say a couple more things from the point of view of an expert witness. When I teach lawyers, how to cross-examine experts, I teach that there's somebody's going to be the tail and somebody's going to be the dog, right? And Brian stresses that the lawyer, that the expert has to be in control of the narrative. But that's because he's from Canada and he's nice. But I teach that the lawyer, the cross-examiner, has to be the dog and the witness is the tail. And if you as a expert, I remember I started testifying as a master's level professional in 1976. How many people are master's level professionals and testify? Okay, well, when I was all but dissertation in the mid 70s and started testifying as an expert, they had to keep reinforcing in me that you are an expert by rule on the basis of your education, training, or experience. And you can be just as good an expert as anybody else with 8 million degrees like Professor Sherry and I have. And it's the weight that's going to be given to your testimony by the court. So when you start out as a master's level professional, social worker, a psychologist, a counselor, a marital and family therapist, you have valuable stuff to say. So remember that the cross-examiner is going to turn you into the tail, and she's going to be the dog, and she's going to wag you all over the courtroom. How do you deal with that? Well, you just got some terrific advice from Professor Sherry. What I say to people that are learning to testify is keep your feet flat on the floor. Do not cross your legs. Do not fold your arms. Put your hands on your knees. Be grounded. And when the lawyer is going faster and faster, you know what I'm talking about, Virginia. When the lawyer's going faster and faster and faster, don't go for it. Let me think about that question for a moment, counsel. No judge is going to interrupt you from doing that, but if you're starting to go down a slippery slope, remember to keep your feet on the floor, your hands on your knees, grounded, and slow the blank down. Because if you don't, I gotcha. Virginia, you got him. We gotcha. You don't want that, because then you get taken out of your comfort zone. And everything that Professor Sherry's just told you is like, and you've lost it, and you're going to get wagged all over the courtroom. So slow down. You'll see me going after her today. And we're going to be arm wrestling up here.
And then we're going to take a vote. Who was the dog and who was the tail at the end?
Here, hold on to that. Okay, so start us off, guys.
So we have a case study, right? I made this up. This isn't even close to any of my cases, and I mean it's all of my cases, all put into one in some ways. I want to make one quick note that I didn't say earlier. For the women in the room, you will be harassed, I'm going to guess, about a rate of 10 to 1 compared to the men. Defamed on social media. Somebody has told everybody that I should be raped. It's rough out there. And so I really encourage you to be kind to yourself. Figure out your coping strategies for dealing with some of that stuff. I don't do social media anymore. And if I don't look at it, it doesn't bother me. And I tell people, don't send me that stuff. My friends would send me like, oh my God, this was on my Twitter feed. I don't care. Don't send me that stuff. Nothing I can do about it. So I don't need to see it. I also put in a security system in my house. It's like Fort Knox and has video cameras all around it. It makes me feel safe, and then I can sleep at night, But get with other women that are dealing with this. If you have a supervision group, that's awesome. And because, you can't talk to your husband about this stuff or your wife about this. They don't, just sometimes I'm like, I would like to talk to my husband, but just to tell the story is freaking 45 minutes before then I can tell him about the 2-minute interaction that made me so upset that day, So having a good consulting group really helps with that too. Okay, so our case study. We have a 9-year-old boy. He has an ADHD diagnosis following a neuropsychological evaluation when he was 7 years old. So he had a really good evaluation. This wasn't just like the pediatrician. He attends public school. He has 504 special ed accommodations for his ADHD and takes a stimulant medication, and that medication is prescribed by his pediatrician. The child was conceived following a one-night stand. Mother was a stripper at the time. Father was married and had 2 sons who were teenagers at the time of conception and are now grown and out of the house. Father and wife at the time, who I'll just call stepmother, remained married despite father's infidelity with mother, and that led to the 9-year-old being in their lives. Mother has a bachelor's degree in education. She did some substitute teaching while she was pregnant and for about 6 months after the child's birth. Father is an accountant for a large corporation. Stepmother insisted father get 50-50 visitation, allegedly so father did not have to pay child support. Mother continues to work as a stripper when she does not have possession of the child because it pays better than teaching. Mother alleges stepmother is alienating the boy from her, and father is passive and not intervening. When boy comes back to mother, he calls her a whore, says she works as a prostitute, and says he's seen pictures of her on Facebook, dressed almost naked and whatever, even though he doesn't have a Facebook account because he's too young. Mother says this behavior lasts about a day. The second day, he is quiet and withdrawn, and by the third day, he's back to the boy that the mother knows. I'm sort of, when I was writing this, I think I was assuming that they have week-on, week-off visitation, if that helps. Father defends stepmother, who denies showing son Facebook pictures or encouraging him to think poorly of mother. Custody evaluation with psychological evaluations found that mother has some histrionic traits but is otherwise a well-functioning person. No history of abuse or neglect. She has not been as active at son's school as she used to be because she believes the teachers do not like her because stepmother has told them what she does for a living. However, she's responsive to his medical needs, takes him to his soccer games and practice during her possession periods. The evaluation found father works 60 hours a week and mostly defers to stepmother to care for son during his possession period. The exceptions to this is that he coaches his son's soccer team on Saturdays and periodically takes son on fishing trips with his older half-brothers during his extended summer possession without the stepmother going with them, like a boys' trip. Collaterals noted stepmother has episodes of rage and berates and belittles father fairly regularly. These same collaterals say father is afraid of stepmother and only stayed married to her because she threatened to take their children away from him and leave him penniless, stating, "You got a whore pregnant, no judge in the world is going to listen to you." Sounds familiar, doesn't it? Stepmother was reluctant to be a part of the evaluation. The custody evaluator, she finally did, though. So the custody evaluator diagnosed her with borderline personality disorder. She has attempted suicide 2 times, the most recent time being when father told her about mother's pregnancy. She slit her wrist in father's presence and spent 1 week in psychiatric hospital. She's had 4 psychiatric inpatient stays over the course of her life. Her hospital records stated a diagnosis of bipolar disorder and prescribed a mood stabilizer for her. Stepmother is a stay-at-home parent to son. She's very involved in son's school and tutors him regularly after school to help him with his ADHD stuff. The teachers at school report son would barely be passing if it were not for stepmother, and that he makes better grades and is on time for school when he is in stepmother's care versus when he's in mother's care. Stepmother reports a history of sexual abuse as a child, but would not discuss it in detail with the evaluator. Son appears to be attached to all 3 of his parents when observed with them. However, evaluator did observe one exchange from father to mother where she observed son as distant and would not hug his mother or show her affection. When evaluator asked son about this, he could not answer why he does this to his mother. Mother's petition for modification is to have son full-time and for father to have standard visitation. She also wants the court to document a finding of parental alienation. Father's counterpetition is for mother to have supervised visitation only, citing her job as a stripper being detrimental to the son's development. However, when the evaluator talked to father about his counterpetition wishes, he was unable to verbalize exactly how her job negatively affected son. Custody evaluator found that stepmother was engaging in alienating behaviors. The son was mild to moderately alienated and did not advocate for a change in custody or time away from father-stepmother possession. Instead, recommended family therapy. Father and mother entered into an agreed order to participate in family therapy, but stepmother has refused to participate in family therapy, and because she is not party to the suit, could not be ordered to do so. There have also been 2 calls to CPS against mother since the evaluator issued her report. One alleged mother was watching porn with son. The second alleged son reported mother touching him inappropriately after helping him shower. Since the custody evaluation was released, stepmother also inappropriately took son to her individual therapist, who wrote a letter to the court stating she believed the son was being sexually abused by his mother and should be removed from his mother's care. So it's totally made up. Demos and Brian are going to ask me totally made up questions about these totally made up people, and I'm going to give them totally made up answers. Let's see how we do.
And the rules, because it's custody eval, both sides can ask leading questions.
Yeah.
Okay,
We're both crossing it.
Okay.
She's a courts expert.
Okay.
Yeah, and as a courts expert, I'm also allowed to testify about hearsay.
Bite me.
What? Bite.
That's what you think. You want to go first? Okay, I'm going to go first. Have a seat, Dr. Sherry.
Demos says not to cross your legs and be grounded and put your hands in your lap. Although,
Excuse me, ma'am, I asked the questions here. So, how many lap dances have you watched, Dr. Sherry?
none.
Okay, so would it be a surprise to you that in Mother's role as an exotic dancer that she regularly gets paid for sitting on the laps of male customers? That wouldn't surprise you, would it?
I don't have any specific knowledge about that.
Well, wouldn't you think that the moral upbringing of a child is important to the court?
Oh, yeah, okay.
Don't you think that you do think that the moral upbringing of the child is important to the court, correct?
To a certain extent, but it depends on who's making the morals.
You don't think that the moral upbringing of the child is important to the court? Is that what you're saying?
No,
Okay, so the moral upbringing of the child is important to the court in your estimation, correct?
Again, I said it depends on who's making the morals.
Okay, so sexuality, sexualizing a 9-year-old boy is probably not a good idea. Wouldn't you agree?
Yes.
Okay, so let's get back to the mother's occupation. When mother makes most of her money, she makes it by sitting on the laps of strange male customers and grinding around in a lap dance, correct?
I don't know that for a fact. I know that she's a stripper, but I don't know the exact behavior that goes on.
What do you think she's stripping? Paint?
No. She may be dancing. She may be just be up there taking her clothes off.
Well,
I don't know, but
all
I
right,
don't know
I understand.
that she's
You don't.
lap dancing.
I understand. You don't know what mother is doing to earn money from strange men in the gentleman's club. I understand that. Okay.
I know that her job is a stripper. That's what I know.
Okay. So how much does she strip?
I think I've told you I don't know the specifics of what goes on in her job. She is a stripper. That is what I know.
So why is the attorney going at this? Why? Why is the attorney doing this? It's going to cause a female judge to feel a real distance from this mother. It's going to cause a male judge to have like, whoa, some kind of feelings. What do you think? Yeah. Yeah, but the attorney's going for this to paint a lurid picture of the mother in the mind of the judge. That's all the cross-examiner cares about. It's painting a lurid, and is Dr. Sherry going for it? Is she going for it? Oh, well, just wait. Now, Dr. Sherry, have you ever been a stripper?
No.
Okay, why not? Object.
Because
Object.
There's no judge here.
Because nobody wants to see what's going on under this. And I would actually say that in real life.
Excellent. She just became the dog and made me the tail. You see that? See how that happened? She did it with humor. She didn't raise her voice, didn't do anything, but she got back in control. Now, Dr. Sherry, let me ask you a question. The number of sexual abuse allegations in this case is concerning, isn't it?
There are two. They were both.
I asked you if it's concerning, Dr. Sherry, not how many.
No, you did ask me how. You said the number of sexual abuse allegations is concerning.
And it is, isn't it?
Well, not necessarily, no.
You notice how I keep trying to interrupt her, and she's not going for it. Come on, Virginia, we're going to get her, aren't we? We're going to get her. So the number, so it's more than one allegation of sexual abuse, inappropriate sexual contact by the mother.
There's two allegations.
And inappropriate sexual contact by the mother is what she does for a living, isn't that right?
Not to children.
Inappropriate sexual conduct is what the mother does for a living. Isn't that true, Dr. Sherry?
I would say no to that.
Good. Notice that she's not going for it.
Thanks.
Okay. Mother's attorney. Hold the applause to the end. Dr. Sherry's made fools out of both Brian and I.
Whatever.
Dr. Sherry, I'm going to start with a question that my esteemed colleague asked you. Isn't it concerning that there are these allegations of sexual abuse against the child emanating from the father's household?
You know, I was able to see the CPS records, and they always black out who called them in, but so I don't know who exactly called in the abuse allegations. However, it concerns me that the timing of them seemed convenient because they occurred right after my report came out.
And isn't it the case that the stepmother inappropriately took this child to her therapist, who was...
Objection to the form of the question, inappropriately. Calls for a conclusion.
It's part of our fact pattern. Okay.
Do you think it was inappropriate that she took?
Is there something wrong with the stepmother taking this boy to her therapist for what turned out to be a disclosure that arguably she knew he was going to make?
Absolutely.
And was that therapist, her therapist, appropriately coming to a conclusion about events that that therapist didn't investigate?
Absolutely.
Absolutely inappropriate or absolutely appropriate?
Absolutely inappropriate. She should have never agreed to see the son in the first place.
Now, Dr. Sherry, you're recommending family therapy as the solution to this overall situation, correct?
Yes.
And what authority does the family therapist have over the participants in this family system?
I don't know that they have much authority. I'm not sure if I understand the question.
Well, you've identified certain problems in this family system that have led to mild to moderate alienation, correct?
Yes.
And you've identified the source of that concern as the stepmother,
Yes.
and the stepmother has said she's not participating.
Yes. Okay. I think
And
I understand.
you've identified the father's working 60 hours a week and being very passive and scared in the family home.
Yes.
Who runs the environment in the father's home?
The stepmother does.
And what is the stepmother's view of the mother of this child?
She does not respect her. She looks down on her. She thinks she's better than her.
And in your view, is there anything in place right now to protect the safety of that child's experience of his parents in the father's environment at the present time?
No.
Why did you not recommend a series of very specific covenants for this family system to follow?
I think at the time I wrote the report, I was hopeful that all three of the parents would participate, but now that it's clear that the stepmother will not participate, I'm rethinking whether or not family therapy is the best idea for this family.
Have you considered whether family therapy, in conjunction with a list of rules for this family system, might be an appropriate response?
I certainly think the Children's Bill of Rights needs to be reviewed with the parents. And certainly any rules that cover some of the issues where the one or both parties have been in contempt of court because they haven't allowed the child to go over to the other one's house, or they don't allow phone calls or contact. Some of that kind of stuff has gone on a little bit. So yeah, to the extent that they violated the court order during this time up until my report, I think that a list of rules like that would be helpful.
Specifically with respect to the father's household, would you, in hindsight, recommend a series of specific changes to the stepmother's behavior that the family therapist can be discussing at least with the father?
I could, but honestly, I don't think the father has much agency in that home, and so I'm not sure that a family therapy model would really help.
So, thank you for that, Dr. Sherry. In terms, therefore, of available remedies, given what you've just shared with the court, Is it not the case that until the father's environment changes, we need to protect this child by reducing the child's exposure to that toxic household?
Unfortunately, yeah, I think that would be better.
Okay. So you see how I walked her from where her recommendations were, showed how they're not likely to work, forced her to think about where this is going at the present time, and is this the right tool at this moment? Not that we can't have a healthy family system ultimately in future, and then got her right to where I wanted her, which is we need a temporary timeout or some severe restrictions on the father's household.
Yeah, not so fast, Mr. Nice Guy. Not so fast. Now, Dr. Sherry, you haven't spent days and days and days in this family home, have you?
No.
And you don't like this stepmother. Isn't that true?
No, I wouldn't necessarily say that.
I see. So you really don't have much appreciation for how much this woman has put into this little boy, considering the circumstances that she's dealing with.
No, I wouldn't say that either.
Okay, well, see, I don't care what she says. I don't give a rip what she says. I'm testifying, and she's not going for it. So I have to paint a whole other picture, whether she agrees with it or not. Okay? Let's see if she goes for it. I noticed.
Hold on one second. The witness usually doesn't get tipped off.
Hey, you're half going for it. You got one leg across over the other one.
I always cross my legs.
Okay,
In my courthouse, we've got a wall
Here
there.
we go.
Nobody can
Here
see
we
me
go.
cross my legs.
Here we go. Okay. So, Dr. Sherry, you understand that stepmother's a deeply religious woman, correct?
Yes.
And you understand that she's done everything in her power to make a good home for this little boy, correct?
I wouldn't agree with that necessarily.
And you understand that the collaterals have told you repeatedly that this woman has bent over backwards to make a good home for this little boy, correct?
Not all of the collaterals.
Okay, collateral 1, collateral 2, collateral 3. Did you just not listen to them?
I listened to them.
Okay, well, they told you that this woman had bent over backwards to make a wonderful home for this little boy, didn't they?
Those three did.
Okay, so considering that this woman has stayed married to the father, continued to raise the two older boys, continued to provide a decent home for this little boy, and has bucked up to the serious moral degradation on the part of the mother all these years, that didn't seem to make much of an impact on you, did it?
I can't answer that question because there are so many false statements in that question. I can't give you an answer to it. Okay, gang. What would you do as a cross-examiner? Let's hear it. What would you do? Yes?
Break it down into individual pieces.
Yep. Break it down into individual pieces. You know, use individual points that you want to get across. How about anybody else? Anybody else got any ideas for the cross-examiner? Yes?
I'd go back to the job, and if you don't know what mom does, how good an evaluation did you do?
Yeah, well, I'm going there. Look, see, I'm going there. I'm going there. She's got her arms crossed. I'm going there. You're not following the Demosthenes.
Go there, Demos. Do it.
Okay. So when mom's a stripper, she practices at home, doesn't she?
No. It's not a virtual stripping.
Well,
it's not
okay.
stripping by Zoom.
What is that pole that she had installed in her family room? What's that for?
I am not aware that she has a pole. She did not have a pole in her house when I did my home visit.
Okay, so you didn't see it. She didn't show you how she uses that.
I'm not aware that she has one.
Okay, not freaking going for it. Not going for it. Okay. So, you said you understood that the mom was deeply religious, stepmom was deeply religious, and that she's been providing school support for this little boy, correct?
Yes.
And she's been, whereas the stripper mother doesn't trust the people at school, correct? That's what you said in your report, correct?
Yeah, she feels insecure around the people at school.
Well, I can certainly understand why. So so remember, if you got the cross-examiner who's losing is going to try to paint a picture despite what you say, despite what you're doing. And if you should be able to hear the trapdoors opening on the Shark Tank. And so you should hear the doors opening in the Shark Tank and not get backed up. So no, I don't know. No, I didn't see that. No, I don't understand what you're talking about. Okay, well, let me ask you this. As a stripper in the gentleman's club, mom's hours are from 4 o'clock in the afternoon to 2 o'clock in the morning, correct?
They're not exactly. They're more like 9 o'clock at night until about 3:30 in the morning.
Okay, so at the time when every elementary school child should be asleep in bed, correct?
Yes, but she doesn't have possession of the child when she's working.
See? I'm trying to be the dog and make her the tail, and she just turned it back around on the cross-examiner again. Now, so were you in the mother's home with the little boy at the times when at times between 9 p.m. and 3 a.m. in the morning?
When they were both there?
Yes.
No.
Okay. When what's the child's bedtime? Boom.
I'm like, I don't have children of my own, so I'm like, what is a 9-year-old's bedtime? It's
9 o'clock.
8 o'clock during the school week and 9 o'clock, 10 o'clock on the weekends.
Okay. So so you talked to the biological mother about her job, and you talked to her about her child care arrangements, correct?
Yes, and I talked to her boss about her job as well.
Okay, so you talked to her boss at the gentleman's club.
Yes.
Okay, did he give you any idea at all about the amount of money she makes in tips?
God, that's a good question.
Damn right, it's a good question.
If I said yes, I wouldn't be able to tell you what that was. No, I didn't ask that question.
Good. It doesn't hurt her opinion that there's a question she didn't ask. It doesn't undercut her at all. So she just avoided that trap. She just didn't fall into the Shark Tank on that one. Okay, don't you think it's relevant to know that the mom makes the bulk of her income from sitting on the laps of men with her brassiere off and rubbing herself on them?
No, I think it's important that mom has a job that is legal, and she gets paid well for that job, and she gets paid enough to be able to take care of her son and provide for him even some extra things that he might need in terms of being able to afford his psychiatrist and in those types of things. What she does is perfectly legal, and she makes a good living, and that's an important part of taking care of a child.
But the stress on the father and the stepmother of this lifestyle is overwhelming, isn't it?
They don't like it, but it's not mom's responsibility to take care of their stress.
Yeah, but I'm asking you about the psychological home for this child with his father and stepmother of the primary home, and the impact of this immoral sexual occupation. I'm sorry.
Well, maybe they need to watch a little more porn together and get it out of their system. I don't know.
Right.
Don't say that.
Right. Okay. You're going to have to deal with rampant sexism, being undercut, being demeaned, and you notice that Professor Sherry is not going for it. Now, as a California lawyer and another California in the room, I mean, we both know that we'd get shut down, about 5 minutes into this. But we're just doing this for illustrative purposes. Yes.
You're saying that the behavior of the mother is not right. The father went there and impregnated mother. Is that not something that you could, I don't know, because I don't know how the system works, but being so moral, but then even doing something that apparently seems to be immoral for you, wouldn't you give that feedback?
Did everybody hear her question? She said, you're talking about how immoral this mother is for being a stripper, but what about the fact that the dad went to the strip club and then got her pregnant? So what about his morals and that sort of thing? And she's asking if, that is something that would come up. And I would say yes.
Let me just stress that. That was 9 years before, and arguably should not be the morality aspect of this, to some extent, is not a child-focused inquiry. It is what it is. People have affairs even, as opposed to just a one-night stand out of their marriage, and that doesn't prohibit them from being a parent. People have all kinds of jobs. It doesn't prohibit them from being a parent. And the concern that I would have with the whole line of questioning is it introduces the specter of what's called contextual bias, which is background facts that are not really directly relevant to a plan of care for a child, that are meant to color, like some computer-generated color in the background that is confusing. And contextual bias is one of the hardest biases to get focus on, but it's real. And so,
Would you mention it? It's the bias that is being created, and it's a double moral. Would you mention it?
well, I might do that in closing submissions. It's not really relevant for my cross-examination here. But for example, if the report had made all kinds of moral judgments or seemed to have been clouded by moral judgments, then I'd go at the expert about an exhibition of contextual bias.
Oh, an exhibition. I love that. I love an exhibition. Right. Isn't that what Mom does in her job?
I actually would say, I kind of would want him to ask me that one question. Isn't it true that Dad went and saw her and that's why we're here? And then be like, and then after I say yes to that, then go, but that's not why we're here today, is it? No. And then we can come back to it. Like, I do think that one question would neutralize to some extent this whole thing he's doing, and then help get us back on task. Yeah. Sorry.
Okay. Well, I mean, what I'm doing to her was done to me in Missouri when I was there, and the cross-examiner read something that I had said about Christians making a big show of being Christians, and how that was foolish or undercutting in some way. I forget the context that I was interviewed by somebody. So knowing that the judge was a fundamental Bible-beating, sanctified Southern Baptist. This guy brought out my quote. Fortunately, he didn't know that in the Greek Orthodox Church, I was a deacon and a Sunday school teacher. And so I hit him with a couple of Bible quotes, which I watched the judge write down.
Oh, my God.
In a very respectful way. I said, well, sir, let the words of my mouth and the meditation of my heart be acceptable in thine sight. And, from the Psalms. So you can, you might be able to risk it and go that far to defuse it. And you've watched Dr. Sherry undercut me and diffuse me and just not go for it over and over again. But be careful. Be careful if you're going back at the lawyer. Be careful, because it's her turf. This is her courtroom. This is her city. This is her judge. They know each other. She's contributed to his campaign, or he's contributed to her campaign, right?
Maybe.
Hey, I'm just saying.
Not enough to have to report it.
Listen, smarty pants. Okay, so the cross-examiner may try to paint you as smarty pants, it may be important to do that. For example, I had an incredibly difficult trial, 22 counts of life felonies, and I had an expert. I was in North Georgia, and I had an expert on the stand, and I said, let's see, bachelor's degree, Harvard University, MD, Harvard University, psychiatric residency, Harvard. That's a little snooty, isn't it? Whereupon Bill Burnett said, yeah, it's a little snooty. And boom, everything was fine after that. There are stage business that you try to do from time to time. And so as a cross-examiner, I'm trying to do some stage business and play on sympathies and do all sorts of things, because I got a losing case here in spades. The evaluation says stepmother is a frickin' harpy, right? And she's nuts. Now, you characterized this long-suffering woman's emergency psychiatric, the stress-related emergency psychiatric hospitalization after suffering through all the indignities of this moral depredation as something that was wrong with her, didn't you?
I didn't characterize her as anything. I just gave her a diagnosis.
But you're not her treating therapist, so what business have you got giving her a diagnosis?
I was ordered by the court to do an evaluation, and you don't have to be a treating therapist to give a diagnosis. I'm absolutely within my board rules and the rules of the court to do that.
Sure. Okay, so you notice? I'm trying to be the dog, and I just got it taken away from me again. And she's doing what she told you she was going to do. She's sticking to her rules. She's sticking to her rules and saying, this is my job. This is what I'm supposed to do. Yeah.
If you know you have a witness, an expert who's been well prepared and isn't going to go there, at some point you want to stop doing that because...
Oh, heck yes. Heck yes. I mean, you play on your judge's sympathies as far as you can, and then the thing that works best for me when I'm an expert witness, in 20 years of publishing cross-examining experts in the behavioral sciences, my fear has always been, in 45 years of testifying as an expert, that somebody's going to try to cross-examine me with my own book. It hasn't happened yet. So you got to know when to get out. And so I remember doing a case. We were on Court TV doing this big sexual assault case in California many years ago. And this prosecutor, I'm doing my direct, and this prosecutor asked me a couple of questions, bang, and a couple more questions, bang. She looked over at the cop next to her and said, no further questions. Sometimes you just got to get out, and you've got to use your other witnesses to backfill the holes that have happened, right? And as an expert, if you can shut the cross-examination down by doing what Professor Sherry is doing, by being solid, reasonable, sticking to your report, not going for it, the cross-examiner that keeps trying to berate you is a moron. Because he who throws dirt loses ground. Okay, Brian, your turn.
So Demos is 100% right that if you have probed, use the 80-20 rule, and you probed at the areas of what you perceive is the weaknesses of the expert's position, what the expert might, for good or bad reasons, not have explored, the more arguable parts of the expert's analytical work that you can probe, and you see you're getting nowhere, then you move on.
What's the 80-20 rule? I don't know what that
The 80-20 rule, is that a Canadian expression? You go with your best. You get 80% of the benefit from 20% of the issues or ground to cover. And at some point, you just try and dent the expert's testimony to the extent you can, and you go back to your fact witnesses because the expert's report is based on the factual inputs. If you can pull out or cast doubt on the factual inputs or introduce other facts that were not known to the expert, because the trial generally is going to hear a broader range of evidence and possibly even more current evidence. Sometimes the expert report is 6 months old, 8 months old by the time you get to trial. So these are things you don't wing on the spot. In other words, Demos would know heading in, okay, here's what I'm going to try, and I'll get the most out of it, and if I'm dealing with, a real pro and I'm not getting anywhere, this is where I'm cutting it off and letting the witness go. The same applies for fact witnesses. So a lot of what you've heard here today, if there's a fact witness that's doing a lot of damage to your case, the approach is the same. For any parents here in the audience, the rules of testimony are the same. Stay with what you know, don't argue, be helpful, even more so because you're being judged as the parent. So there's basic rules of being a witness that apply to experts, that apply to the litigants themselves, that apply to collateral witnesses, and it's the lawyer's job to prepare them. So here, since Dr. Sherry was the court's witness, both Demos and I were fully entitled to prepare her in advance, to meet with her, to explore areas of interest that aren't 100% apparent from her report. You haven't heard us ask her any hypotheticals, which would often happen if the report is 8 months old already. Hypothetically, if in the last 6 months, or Dr. Sherry, you weren't here when Mr. So-and-so testified, but this court has heard evidence that blah, blah, blah. How would that impact on your analysis? Doesn't this show that the risks you've identified are in fact playing out? And so that's a whole other area of supplement.
Okay, we've only got a few minutes. Tell them how you felt under the cross-examination. Tell them how you felt when I was embarrassing you and spanking you and doing all that, or trying to.
I felt fine. I wasn't embarrassed, and my heart rate didn't go up or anything. It's like I'm detached to a certain extent. It's not this is, what's the saying? We have a saying, not my monkey, not my circus, but right? It's kind of like that. I will say, to the points that Brian brought up, I often ask if I can be in the courtroom to listen to mom and dad testify and let me testify after that, when it's been several months since my report came out, so I can hear what's been going on. The second point I'll make is that yes, I can talk to the lawyers, but I try to be really careful about that. And so what I do is I'll say, one option is that we can all be in a room and talk together. One option is, well, maybe you'd like to depose me. And then another option is to say, call the other lawyer and say, Brian wants to talk to me a little bit about my report, my findings, so I want to offer you that same amount of time to do the same thing, because you don't want to align with either side, even though your report is more supportive of one side or the other. Yes. Are you serious? That feels like the other attorney needs to object to relevance to me. Exactly. It's like, is this all you have? Okay. Yeah.
Get the rules from the jurisdiction you're testifying in about inquiry into specific conduct. Most jurisdictions don't allow them to go on an ad hominem hunting. You had a question?
Yeah, I think so, and I've had them. Yeah, he wants to know if since I made a diagnosis, the first part was, would you question whether I should have made the diagnosis, and then second, question the relevance of making that diagnosis. And I do get that question fairly frequently, and my response is usually, to tell you the truth, I really don't care about diagnoses. I've made a diagnosis because that's what you put in the court order that you all wanted me to do. And I know it's important a lot to lawyers that there be a diagnosis. But honestly, to me, I don't really care what's wrong with anybody. They just need to stop doing X, Y, Z to this child. And that behaviors are all I care about. Mm-hmm. And it speaks to the level of pathology. Yeah. Sometimes it's not relevant. I think in this case you could argue. Yeah, I mean, yeah, for sure. Okay, you guys can come up to me and ask me questions.
All right, we'll be here to answer questions. Thank you very much.